Andre, appreciate the time this evening. SARS just won a fairly important case in the Supreme Court of Appeal. What's the details around their victory?
Thank you so much, Simon, and good evening to yourself and your listeners. In essence, the Supreme Court of Appeal has confirmed that SARS's strict approach when taxpayers submit nil returns and cannot back them up with proper records. This matter involved a taxpayer, being an attorney, oddly enough, who filed 6 consecutive nil returns. But after a SARS audit, SARS discovered his bank statements and found income that should have been declared under his taxable income. SARS then issued assessments that include a 150% understatement penalty for intentional tax evasion.
Yeah, okay. So, I mean, a couple of lessons here. And I suppose the first is, if you're going to submit nil returns, you've got to have those proper records. As I understand, he tried at some point during the case to claim inadvertent error. That was thrown out in the sense that you've really got to prove that you made an error. You can't just kind of claim it.
100%. And there are very, very strict guidelines in the Tax Administration Act in terms of a bona fide inadvertent error. Further, being an attorney and being someone that had the assistance of professionals in submitting these returns over the years, Simon, either one, he was ill-advised, or either he submitted nil returns and thought that he could get away with it. I just want to circle back to your comment earlier in that when someone submits a nil return, or any return actually, that they should be in possession of the proper records, failing which SARS may audit you and may impose understatement penalties for the tax periods in question, up to 150% for intentional tax evasion as the taxpayer in this instance.
It's a giant number. It is important, though, perhaps, and less direct with this case, but we are human. We will maybe make errors sometimes. SARS is going to, in some cases, and you'll have more insight into this than we do, but, if we make an error, SARS accepts that we are human, as long as they say, look, this really was a legitimate error that you made.
Certainly, there are legitimate errors, and there are applications that a taxpayer may make in terms of a request for remission of penalties under either Section 217 of the Tax Administration Act or Section 218 of the Tax Administration Act. SARS does accept that mistakes are made, and when a verification or audit is raised, SARS, generally speaking, does give taxpayers the opportunity to voluntarily inform SARS of an error that was made. And generally speaking, SARS will not then impose penalties. In instances where a taxpayer wants to go back over several years and inform SARS on a voluntary basis that they have not declared, or they have understated their taxable income or any tax liability whatsoever, a taxpayer may make use of the voluntary disclosure program administered by SARS and regulated by the Tax Administration Act. And in terms of the voluntary disclosure program, SARS legislatively must waive all penalties except in instances of intentional tax evasion or gross negligence, which then will carry a very much smaller penalty of 10% and 5% in each instance, as opposed to 150%.
Wow.
So there is a very, very big pro for taxpayers coming forward on a voluntary basis, Simon, to declare that.
And another outcome from this case is that there's a sense that SARS can make estimated assessments when there is incomplete information. And I get the point from SARS's side, which is to say, look, we don't have everything. We're going to have to, in essence, estimate. And the court will uphold that.
Yes, certainly. SARS may make estimated assessments where information is incomplete. This information will come from third parties, in this instance, such as the taxpayer's bank. And SARS would then have access to the taxpayer's bank statements to estimate his income and then raise the relevant tax for that period. It is important to note, Simon, that by the mere fact that SARS have raised an estimated assessment, that does not detract from the taxpayer's obligation and responsibility to firstly file a tax return and to place SARS in possession of the requested supporting documentation to evidence the tax position.
And perhaps the key broader point of the case for people out there is that, the risk to taxpayers that when disputes are not managed properly, and when there's a lacking of supporting and proper documentation, both hugely important. I am not an expert here, and it's important to get experts on board and make sure I've got the documentation.
100%. It's a reality that where disputes are not managed strategically and supported with proper documentation, taxpayers do face a large risk there. We do see many instances of taxpayers trying to go at it alone, which isn't advisable. And I suppose a saying that comes to mind now, especially in the present instance where the taxpayer being an attorney represented himself, I'm sure you know the saying, Simon, that an attorney who represents himself as a fool for a client.
Yeah.
So it is important, even if you are an attorney, to consult with someone that is sufficiently skilled in that specific area of the law, being tax dispute resolution in this instance. And then another message important for all taxpayers is, by the mere fact that you filed a dispute does not automatically suspend the tax liability. The Supreme Court of Appeal have confirmed for us, Simon, that that SARS can still pursue a tax liability unless there is a suspension of payment in place with SARS.
I believe that there. That's Andre Daniels. He's head of tax controversy and dispute resolution, Tax Consulting SA. Appreciate the time.